Good morning, everybody, and we're about to get started for the our webinar for the AB40 Abuse Reporting Changes. My name is Annie Kim. I'm assisting Joe Rodriguez with this webinar and just wanted to go over a few housekeeping. Let's see. So we're going to record this webinar and it will be posted to the Aging website. And that information will be given to you at the end of the webinar. It will be posted probably maybe in about a week. And if you have any questions during the webinar, if you can please type your questions in the questions box on the panel up on the screen, and then Joe will address those questions at the end of the webinar. All right, and we'll go ahead and get started with Denise Peach, Chief of the Community-Based Adult Services Branch.
Good morning and welcome everyone to this session on mandated reporter requirements changes that are coming down through AB40. I want to welcome all of you and thank you for taking time out today to participate in this session, time away from the program floor for those of you running day programs. So thanks for taking the time today. This is an important session today to explain some changes that are coming down, through AB40 that are going to change some of the things that you already are familiar with regards to your mandated reporter roles, your duty to report as day program providers. I want to remind you just briefly before I hand this off that Welfare and Institutions Code 15600 is where the reporting requirements begin in the Welfare and Institutions Code. If you're not already familiar with those sections and the ones that we're going to be going over today that are indicating changes, to please become aware of those sections. This is where the definitions exist for who's a mandated reporter. Adult day program providers are defined specifically as care custodians in those statutes. Any administrators or employees of the centers, that includes any of the support staff in these facilities. So be sure that you're aware of those requirements and definitions, the kinds of abuse that are included under those reporting requirements. If you're not already acquainted, definitely get yourself acquainted with those. Ensure that your centers have policies and procedures to address the requirements. Ensure that your staff have been informed of their reporting requirements upon hire and they understand what constitutes abuse and that they've demonstrated that they understand by signing a statement and including that in your personnel records. So that is all evidenced at the center. So with that, I'm going to hand off to Joe Rodriguez, who's going to walk us through the changes that are coming up through AB40 to those requirements.
Thank you, Denise. Good morning, everyone. I'm Joe Rodriguez, the California State Long-Term Care Ombudsman. Thank you for joining us today on this webinar. AB40, which was signed into law by the governor last year, went into effect on January 1st of this year and changes the mandated reporting requirements for mandated reporters who work in long-term care facilities. Adult day health care facilities, or CBAS sites, are considered for the purposes of the Elder and Dependent Adult Abuse Reporting Laws to be a long-term care facility. And so as mandated reporters, your reporting scenario is a little more complicated than mandated reporters in other settings, because you may be suspecting or witnessing or have knowledge about abuse that occurs not only in perhaps a CBAS or adult day program site, but possibly abuse occurring in a senior's home or abuse that has occurred in a skilled nursing facility. So your reporting requirements are going to be a little more complicated. Why did the governor sign AB40 and why was AB40 introduced? Well, elder and dependent adult abuse occurring in long-term care facilities prior to AB40 was reported to either the local long-term care ombudsman program or the local law enforcement agency. As it's established in the Older Americans Act, there are very strict confidentiality and disclosure requirements in the Older Americans Act when it comes to the Ombudsman program. Ombudsmen generally don't go into adult day programs or CBAS sites to perform our traditional Older Americans Act advocacy and complaint resolution that we do for residents of skilled nursing facilities and residential care facilities for the elderly. Ombudsmen can only disclose the identity of a resident that they're working with when they have the consent of that resident or that resident's legal representative. And so here in California, we're one of 6 states that has given responsibility for the receipt and investigation of these reports of abuse and neglect to their ombudsman programs. In most other states, abuse and neglect that's institutional is usually investigated by either adult protective services or by the respective licensing agency for that facility type. But because of the confidentiality requirements that we have in the Older Americans Act, if we receive a report of abuse or neglect, we can only disclose the identity of that individual, the victim, with that person's consent or with the consent of that person's legal representative. That presents a problem for us because we may have information that needs to get into the hands of law enforcement, but we can't share that information if the resident declines to give us consent. Many residents are fearful of retaliation and don't want to be subject to further abuse, and so there is great fear among residents and disclosing their identities for fear of being treated differently, fear of being treated worse, fear of additional abuse. So AB 40 was introduced to relieve this burden off the shoulders of the Ombudsman. The Long-Term Care Ombudsman Program data showed that in fiscal year 2009-10, almost 3/4 of elder and dependent adult abuse victims did not consent to disclose their identity. So because of that, law enforcement may not be able to investigate some criminal abuse that has occurred in long-term care facilities. AB 40 went into effect on January 1 of this year and requires initial reporting of some types of physical abuse directly to law enforcement. Attempts to align reporting requirements with requirements for skilled nursing facilities under the Elder Justice Act provisions of the Patient Protection and Affordable Care Act. So in 2010, as a part of the Affordable Care Act, the Elder Justice Act was included. In the Elder Justice Act, there are provisions that require long-term care facilities that receive $10,000 or more in federal funds to report the reasonable suspicion of a crime to local law enforcement. And so AB 40 attempted to weave that requirement into California law as well. If the abuse is occurring in a long-term care facility in which ombudsmen have jurisdiction to investigate abuse, is really the question that the mandated reporter needs to ask himself before determining how and to whom do I report. If it's physical abuse, did it cause serious bodily injury? Did it cause harm? Then a report needs to be made to both local law enforcement and the local ombudsman program. In addition, mandated reporters also need to contact their respective licensing agency, either the Department of Public Health or Department of Social Services. As Denise mentioned earlier, the Elder and Dependent Adult Civil Protection Act is in the Welfare and Institutions Code, section 15600, and AB 40 amended some of the definitions and the reporting procedure that's defined for us in the Welfare and Institutions Code. I mentioned that reports of physical abuse that cause serious bodily injury must be reported immediately or as soon as possible by phone to local law enforcement and to the ombudsman and licensing agencies. What does serious bodily injury mean? This definition here is taken right from the Elder Justice Act. Serious bodily injury means an injury involving extreme physical pain, substantial risk of death, or protracted loss or impairment of function of a bodily member, organ, or of mental faculty, or requiring medical intervention, including but not limited to hospitalization, surgery, or physical rehabilitation. So, what happens when a mandated reporter suspects that an older person or a dependent adult has been the victim of physical abuse resulting in serious bodily injury? If the mandated reporter believes that this event occurred at the facility or at the skilled nursing facility, they are to report by telephone to local law enforcement immediately, but no later than within 2 hours of obtaining knowledge. The mandated reporter also needs to report in writing on the SOC 341 form to local law enforcement, the local long-term care ombudsman program, and to your respective licensing agency within 2 hours of obtaining knowledge of the suspected abuse. Now, if you're suspecting abuse that has occurred in a home setting, not in the CBAS or adult day program site, not at the skilled nursing facility, if it's abuse that's occurred in the community, then you would still have the option of reporting to either local law enforcement or your local adult protective services. So we want to make sure that you're clear on the distinction. If the abuse is suspected to have occurred at a facility, CBAS, adult day program, skilled nursing facility, the immediate call goes to law enforcement and the written report to law enforcement, ombudsman, and the licensing agency. If you suspect the abuse has occurred at home, then the mandated reporter would contact either the local law enforcement agency or adult protective services. For physical abuse that doesn't result in serious bodily injury, the mandated reporter would report by telephone to local law enforcement within 24 hours of obtaining knowledge of the suspected abuse. The mandated reporter would also report in writing, again on the SOC 341 form, to local law enforcement, the long-term care ombudsman program, and licensing within 24 hours of obtaining knowledge. But, just to complicate this even more, if there's physical abuse that doesn't result in serious bodily injury, and if the alleged perpetrator is a resident or participant or patient and has a physician's diagnosis of dementia, the mandated reporter needs to report by telephone to local law enforcement or the local long-term care ombudsman program immediately or as soon as practicably possible. The law also says you need to report in writing on the SOC 341 form within 24 hours to either the ombudsman or law enforcement. No report to the licensing agency is necessary. So this is a situation where a resident who has a physician's diagnosis of dementia, which many of your participants or patients may have, and if they're acting out as a result of their disease, not because they're willfully intending to abuse an older adult or dependent adult, and that physical abuse has been perpetrated by this individual, the mandated reporter would have the option to report to local law enforcement or the ombudsman program. And this was written into the law specifically to address issues that may not really be considered or shouldn't be considered elder abuse in the strictest sense of the phrase, but rather perhaps a care plan issue that needs to be addressed. We wanted to avoid the perception that we're criminalizing dementia in some way, or people who have dementia who are acting out. This is probably a situation that you would be better served by having an ombudsman presence rather than a law enforcement presence. So for other reporting of other abuse that's non-physical, abandonment, abduction, deprivation, financial abuse, isolation, mental suffering, neglect, your reporting requirements haven't changed. You still have the option of reporting to either the local ombudsman or the local law enforcement if those things have happened at a facility. If they've happened at home, you have, again, the option of reporting to either APS or local law enforcement. So AB 40 only addressed physical abuse. All other abuse types are reported in the same way, either to local law enforcement or the ombudsman, or local law enforcement and APS if it's occurred at home. To help matters, we've come up with a mandated reporter flowchart that was sent to conference participants yesterday. At this point, I'm going to turn the presentation over to Lisa Coleman, who's the Executive Director of the California Long-Term Care Ombudsman Association, and she's going to go over the chart with you.
Hello. Thank you for bearing with a little housekeeping there. We have to switch microphones and move chairs around, but I think we're making progress on this webinar, and I hope that we're making it clear to you your role as mandated reporters. I am Lisa Coleman, and as the director for CalCOA, it is my privilege to get to work cooperatively with Joe Rodriguez, the state ombudsman, and his fine staff at the state office. And I am especially excited to be joining with Denise Peach from the Community-Based Adult Services. Providing the very best care to California seniors, it truly requires a collaborative effort. This joint effort we're endeavoring with state agencies, site administrators, the staff, the patients, their families, as well as the long-term care ombudsman. We all have to work together, and it's exciting for us to be a part of that. Just a little background, the long-term care ombudsman program doesn't have a big presence in the adult day sites. We are much more visible in the residential care facilities, but we do have a role in the adult day sites, and unfortunately that role is typically investigating abuse allegations. Now, the long-term care ombudsman program is a federally mandated program. There are ombudsmen in every state in the country. In California, there are 35 long-term care ombudsman programs. We fall under the Older American Act. Currently in California, we have just under 900 field ombudsmen. These field ombudsmen are locally trained, but they are certified by the state ombudsman, and they are certified to follow legal mandates that are required of all long-term care ombudsmen. I share that so that you know that when an ombudsman is in your center, they are following protocols that are mandated by the state. It's not just their individual personal preferences. Now, primarily, ombudsmen have three roles: investigate, resolve, and educate. And it's exciting for us to be a part of this webinar because that fits our role of education, and it's exciting for us to have collaborated with the state office, the state ombudsman office, on this mandated reporter flowchart. The flowchart was funded through a grant from the California Health Care Foundation, and it was all of our goals to help clarify how you are to report incidences of suspected or known abuse. The flowchart, it's designed to flow from decision to decision. So as you're looking at the flowchart, the first question is, did physical abuse occur? All right. Did abuse occur that caused serious bodily injury? Now, Joe read the definition earlier of serious bodily injury, and I'm not going to go and repeat that, but the definition is spelled out on the back of this flowchart with several other definitions. So we've determined whether or not there's serious bodily injury. If there's no serious bodily injury, then we have to go to the next step. Was the incident caused by a participant with a doctor's diagnosis of dementia? These flowcharts are available for you to download from the State Ombudsman's website or from the CalCOA website. I know you got the front cover in this slide presentation, and you can also request a copy from your local ombudsman. Now, towards the bottom of the page, there's a space that's set aside for you to personalize the form with your site's phone information for who you're reporting to, so the fax numbers and the phone numbers to your local reporting agency. So we'd encourage you to take some time to fill that out in advance of actually needing it. Joe pointed out, and then I want to just reiterate, that there have been no changes in the reporting requirements for non-physical abuse. We're going to go to the next page. So no changes. You still are to report to local law enforcement or to your local long-term care ombudsman program immediately or as soon as practically possible, and you still have 2 working days to submit your written form, the SOC 341. And to reiterate again, if the abuse does not occur within your site, so let's say you suspect abuse has occurred in your patient's home, then the appropriate agencies would be either local law enforcement or adult protective services. The Ombudsman's program is mandated to investigate allegations of abuse that occur within a long-term care setting. Your sites, the adult day site programs fit that definition. Now, you're still using your SOC 341, but it does need to be updated. It does not give you a spot to list all of the 3 entities that you would be reporting to. So you just have to add that information under the notes. We know that the Department of Social Services is working on an update. We just haven't been told when that update is going to be made available to all of us. And just an example, I imagine you're familiar with this, or at least you've seen them in the site somewhere. Okay. Cross-reporting. This is kind of a touchy subject. With the passage of AB 40, the ombudsman are required to cross-report. When a field ombudsman is trained, they are trained to the state's certification program, and they must follow those legal mandates when they're in your center. And when they come across care issues and residents' complaints or abuse allegations, it is not your ombudsman looking to cause you or your center trouble. It is the ombudsman following their mandate to investigate, resolve, and educate. And cross-reporting falls under that category of investigation. Now, working with local law enforcement. We are mandated to cross-report to local law enforcement. The 35 regional long-term care ombudsman programs will and will continue to work with local law enforcement agencies to increase our effective communication. I want to take a moment to just share how, as an ombudsman, when we are investigating an allegation of abuse, it is not our role to tell a law enforcement agency not to come and investigate. I would feel very uncomfortable that it was beyond an ombudsman's training or their authority to tell a licensing, a law enforcement agent, no, you don't need to come. But it is within the ombudsman's scope to share our observations with law enforcement or our suggestions for resolution. The suggestions that an ombudsman may make, especially when we're looking at patient-on-patient abuse or patients that have the diagnosis of dementia, we are very hesitant to make a recommendation of encouraging a law enforcement officer to come marching through your site in a uniform. Chances are, as Joe mentioned earlier, an ombudsman is going to recommend changing care planning, a staff training, or any of the other many options that are available to help resolve an incident at the lowest practical level, because truly it is the Ombudsman's goal to provide the most immediate and appropriate response. The Welfare Code says any victim or elder or dependent adult abuse may refuse or withdraw consent at any time to an investigation or provision of protective services by an adult protective service agency or long-term care ombudsman program. And because that resident or in site centers, that patient has the right to refuse or withdraw consent, cross-reporting may be the only way an ombudsman can ensure that the abuse does not continue. Now, at this time, I'm going to pass this back to our State Ombudsman, Joe Rodriguez, who's going to talk about the Ombudsman Confidentiality.
Thank you, Lisa. Again, going back to what I mentioned earlier, we just wanted to reiterate that local long-term care ombudsmen work at the direction of the resident. And so even in abuse reports, we only act with the consent of the victim and only disclose confidential information after we've received consent from the participant or patient or their legal representative, or if we're ordered by the court to release that information. This part of the statute is consistent, again, with our federal Older Americans Act requirements. So I know that's a lot of information to process, and we wanted to make sure that we allowed sufficient amount of time for questions, and I know you've been entering your questions into the question box on the dashboard, and so we wanted to take the rest of the time today on this webinar to answer those questions. Okay, and so the first question, under serious bodily injury category for abuse occurring in a long-term care facility, is the report to be made to local law enforcement or APS? Again, if the abuse has caused serious bodily injury and it's occurred at your site, at the facility, or at a skilled nursing facility or residential care facility, the report must go first by telephone to local law enforcement and then in written form on the SOC 341 form to local law enforcement, the local long-term care ombudsman program, and your respective licensing agency, whether it's Department of Public Health or Department of Social Services. If you're suspecting serious bodily injury that's occurred at home, then the mandated reporter would report to either local law enforcement or your local APS. The second question we have asks, does this apply to adult day CBAS programs as well as residential facilities? And yes, that's correct. The changes in the mandated reporting laws applies to adult day and CBAS sites as well. Does AB 40 apply to adult day programs, the social model adult day program facilities, as it does for CBAS, the health model facilities? And yes, it does. So if you're a social day program, adult day program licensed by Community Care Licensing in the Department of Social Services, it would apply to you as well. And your report would go to not only local law enforcement, the local ombudsman, but also to CCL as well. Next question, what specific types of physical abuse should be reported to law enforcement? The Welfare and Institutions Code gives us several definitions of physical abuse in addition to the definition that we used earlier today about serious bodily injury. Physical abuse can consist of assault, battery, assault with a deadly weapon or force likely to produce great bodily injury. It could be unreasonable physical constraint or prolonged or continued deprivation of food or water, sexual assault, sexual battery, rape, rape in concert, spousal rape, incest, sodomy, oral copulation, sexual penetration, lewd or lascivious acts, the use of a physical or chemical restraint or psychotropic medication when it's used for punishment or for a period that for which the medication was ordered, or for any purpose not authorized for the physician and surgeon. So those would be the types of physical abuse that would be covered under this statute. Next question. When reporting to the licensing agency, does the report need to go to Department of Healthcare Services and Department of Aging, or just DHCS? If you're reporting, if you're a CBAS site, you would go to both Aging and Department of Public Health, not Healthcare Services. Next question. If the physical abuse happened at home, should we report it immediately to law enforcement? Should we report it to APS at the same time? If the abuse has occurred at home and you've become aware of it, you would have the option of reporting to either local law enforcement or APS. You wouldn't have to contact both. It's one or the other. And next question, report to 3 entities, right? Yes, if the abuse has caused serious bodily injury or is physical abuse, you would report to local law enforcement, the local ombudsman, and your respective licensing agency. If it's a situation where the abuse has been caused by someone with a physician's diagnosis of dementia, you don't have to contact the licensing agency, just law enforcement or the ombudsman program. Licensing doesn't have to be notified under AB 40. Next question. If the alleged perpetrator is a participant with a mental disorder diagnosis, should we go through the same procedure? Good question. You know, unfortunately, AB 40, while it addressed participants or residents or patients who have dementia, it doesn't talk about people who have mental disorders, people who are developmentally disabled. So the mandated reporter is going to need to ask himself or herself, do I reasonably suspect that this is abuse? If you think it might be, then you need to report. If you don't think it's abuse, if you think that the individual has not harmed someone, has not caused physical injury or serious bodily injury, I think I as a mandated reporter would have to ask myself, do I reasonably believe that this person intended to commit abuse or could intend to commit abuse? California law, unfortunately, doesn't make a distinction between abuse, whether it's willful or non-willful. And so the mandated reporter, I think in many cases, errs on the side of caution and makes the report. Local ombudsman or local law enforcement will go out and investigate these reports, and we may not be able to verify that abuse has occurred, but you've protected yourself by reporting it anyway. The mandated reporter is just reporting a suspicion. They're not the ones who make the determination whether this is a verified abuse case or not. You're just the reporter. So you're not having to be placed in a situation where you're making a call as to the substantiation of this issue. Your role here is simply to report. Next question. Why would we need to report an acting outpatient? We are equipped to address that therapeutically. There is no intent, so without any harm, why would this be regarded as abuse? And again, as I just stated in response to the last question, unfortunately the law didn't take into account other participants or individuals who have who are acting out as a result of their mental status or mental disorder or a developmental disability. And so again, the mandated reporter is going to have to use his or her judgment to determine whether or not they're reasonably suspecting abuse and or neglect.
Next question. Let's see, it's similar about regional center serving consumers with developmental disabilities. Again, the mandated reporter is going to need to make a judgment. Does the individual reasonably suspect that abuse has occurred? If they do, they must report. Another question, is an accidental fall of an elder either in the site or at home considered abuse and should be reported based on the AB 40 context? You know, with falls, you really have to look at each case individually. What were the circumstances around the fall? Was the person unsupervised when he or she should have been supervised? Was the individual asking for help to get up and transfer to go to the bathroom, but no help came and they decided to get up on their own? So you really need to look at the circumstances of the case. We all understand that people do fall, but was it a fall that could have been prevented? So, you know, was this neglect or was it truly an accident? The next question is a follow-up question. What mandates would the Ombudsman then follow in responding to such a report of a patient with dementia who's been aggressive towards another patient without injury? Good question. So in that situation, we actually would say, you know, it's more appropriate for an Ombudsman program to respond to a report of abuse involving a resident with dementia than it would be for law enforcement to get involved. You know, law enforcement's looking to see if a crime's been committed. A local ombudsman would be a little more sensitive, I think, to the issue because we're so frequently in contact with participants and residents who have dementia, and we realize that perhaps you know, this behavior would be better managed by looking at the individual's care plan and making modifications to that rather than treating this as physical abuse or as a crime. So we would work in concert with the facility, the participant, and the participant's family and legal representatives to come up with a solution so that whatever happened in the report doesn't happen again. Next question. If two participants, both elderly, fight and one of them got a bruise, does this case be defined as elder abuse? Yes. If two residents are in a fight and one strikes another resident and that resident receives abuse, that's physical abuse and it would need to be reported. Next question. Please clarify which law enforcement agency should be reported to. I assume local means the agency with jurisdiction in the area where the facility is located, but it could also mean the area where the patient lives. Good question. If you're reporting abuse that has occurred in your facility or in another facility, you would report to the law enforcement jurisdiction that would have jurisdiction in that facility. So I know, you know, some of you out there have both the county sheriff and city police. You'll need to determine which law enforcement agency should be receiving reports of abuse in your community. If the abuse occurred in a participant or a patient's home, then you would report that to the law enforcement jurisdiction that serves that resident's home. Next question. Do you have a diagram for abuse occurring not in a long-term care facility? We don't have a diagram for that, but simply stated, if the abuse has occurred in someone's home, mandated reporters would report to either local APS or local law enforcement. Next question. Can you discuss and clarify the scenario of an ADHD participant with and a doctor's diagnosis of dementia abusing another participant within the ADHD program? Sure. as I said, California law doesn't make a distinction between willful and non-willful forms of abuse. It just basically considers abuse to be any, physical, neglect, financial, abandonment, isolation, abduction, or other treatment with resulting physical harm or pain or mental suffering. It could also be the deprivation by a care custodian of goods or services that are necessary to avoid physical harm and suffering. So in the scenario where you have a participant with dementia who strikes out and hits another resident and knocks that resident to the ground and that resident is injured, because the law doesn't take into account really willful or non-willful forms of abuse, this caveat was written into AB 40 that acknowledges that, even though someone was hurt here, it may not be truly willfully intended, and an ombudsman response would be perhaps more appropriate than a local law enforcement response. So as a mandated reporter, when a resident or a participant in your program is injured by another participant or someone else, you as the mandated reporter have the responsibility to report. Whether or not we actually code that or verify that abuse occurred is another story. So this caveat in AB 40 about participants with a physician's diagnosis of dementia was meant to acknowledge that while it may not be willful abuse, something happened that harmed another resident, and that's a reportable activity. Okay, next question. What if staff at an adult day program observes physical injuries that he or she believes was sustained in the client's licensed group home? If two participants, so what if the abuse occurred in a licensed group home? Group homes aren't considered long-term care facilities, so they're actually covered by APS. So if the mandated reporter suspects that the physical abuse occurred at home, then they would call either Adult Protective Services or the local law enforcement agency. Good question. Thank you. Let's see. Next question. If two participants in an adult day health care center do not get along with each other and argue with each other, they both cry after the verbal fight, do we need to report it to local law enforcement? No, because there's been no physical harm. There's no serious bodily injury. It may be a verbally abusive conversation, or it may be just an argument between two older persons. The mandated reporter is really going to need to assess the situation and try and determine to the best of his or her ability whether or not what occurred constitutes a form of verbal abuse. I would say if the mandated reporter is unsure as to whether or not this argument, this fight resulted in verbal abuse, I would say play it safe and report it. Report it to the ombudsman, and we will make the determination whether or not abuse has occurred. It's just better to protect yourself that way. Okay, next question. We had a patient pinch, hard skin broke another participant. Both have dementia. Nurses were able to appropriately treat wound with first aid only. We wrote an incident report and informed caregivers and the MD. Should this have been reported to law enforcement, the Long-Term Care Ombudsman Program, and the licensing agency? In this scenario, if the resident had dementia, as you described, then it should have been reported to either ombudsman or local law enforcement. You wouldn't have to report it to the licensing agency. Okay, next question. If the client resident participant has a diagnosis of severe dementia and their family representative refuses to consent, although the abuse is ongoing, what do we do? You don't need to have the consent of anyone to make a report. Your obligation under the law is to report instances of suspected abuse or neglect. So you would report even if the resident or their family declines to give you consent. The consent issue comes into play only for the ombudsman. We need to have consent of the resident, participant, patient, or if they can't give consent, their legal representative to disclose that person's identity and cross-report to another agency. So as a mandated reporter, you don't need consent from anyone to make a report. If you reasonably suspect abuse or neglect has occurred, then you would comply with the mandates of the law and report. Next question. If a participant pushes another one and it results in bodily injury, does it constitute an act of abuse? Again, you have to look at each situation individually, but in this scenario, if a participant is pushing another resident and the other resident is injured, that would be considered physical abuse and would need to be reported. Next question. Does it apply to work centers or work activity programs which are vendored with regional centers but not licensed through community care licensing? Good question. No, it doesn't apply to work centers or work activity programs. So if you believe that abuse has occurred at a work center or a work activity program, then the report would go to either local law enforcement or local adult protective services. Next question. What about reporting threats of bodily harm? Good distinction. You don't necessarily need to report threats of bodily harm, although if I was a mandated reporter, I would take precautions to monitor the individual making threats and take steps to make sure that the person at the other end of that threat is protected. Next question. Let's see. Where do observation of bed sores fall? No serious bodily injury or no serious bodily injury, or does it depend on the wound stage? We would consider pressure sores that are untreated, pressure sores that are out of control and painful to be a form of neglect. It could, in some cases, be physical abuse as well because the person is experiencing great pain. For those reports, I would suggest that a report be made to either, to both local law enforcement and the local ombudsman program. Even though the bed sore may be a result of neglect, it is causing suffering and pain, and so, if it's depending on what you're seeing, you're really going to need to make a judgment call. Okay, next question. Information of org chart for long-term care ombudsman program, geographically, where are they located? What is the contract numbers? Okay, good question. If you go to our website, www.aging.ca.gov, and navigate to the aging programs section of our site, we have on our website a list of all of the ombudsman programs by county with their contact information. So you can access that list there. And again, that website is www.aging.ca.gov. Next question. Okay. is APS and Ombudsman considered the same agency? No, we're not the same agency. Depending on your county, Ombudsman and APS may be in the same department at the county, or it may be in a separate agency. Our primary role as Ombudsman are to be advocates for residents in long-term care facilities, SNFs primarily, and residential care facilities. We have a quasi-APS function when it comes to the receipt and investigation of reports of abuse and neglect, but by design we're different than APS, and we're not the same agency. Next question. For serious injury, we are not reporting to APS. Well, again, if the abuse has occurred in someone's home, then you would report to either APS or local law enforcement. If the abuse has occurred in your facility or in a skilled nursing facility or residential care facility, you would report to local law enforcement and the local long-term care ombudsman program and your licensing agency. Next question. How are law enforcement agencies being oriented to the new law? Great question. Last fall, after the governor signed AB 40, we developed a cover letter that went out to all local law enforcement jurisdictions in the state, along with a sample or draft model memorandum of understanding between the local law enforcement entity and our local long-term care ombudsman program. The cover letter explained AB 40 and the changes in the reporting requirements. The MOU outlined responsibilities for how local law enforcement and the local long-term care ombudsman program were going to respond to reports of abuse. Because now that we have the same information, there's not a prohibition about disclosing identities. We know that local law enforcement has the report. They know that we have the report, and so it wouldn't be uncommon for local long-term care ombudsman program to contact the local law enforcement jurisdiction to determine what they were going to do with the report, and if they needed assistance in the investigation of the report from the ombudsman program, or vice versa. And we also conducted a webinar for local law enforcement earlier this year that also went over these changes as well. So the next question, now it sounds like reporting to 4 sources for serious bodily injury: law enforcement, aging, public health, and ombudsman. Did I get that right? Yeah, you're right. There's what's confusing here is there's the individual mandated reporter's responsibility to report abuse, but then there's also the facility responsibility to report abuse as well. And so just as you would report any unusual incident, you would report this to CDA, CBAS as well. Whether or not you use the SOC 341 form is another story. You would probably use your own incident reporting form. Okay, next question. As a staff member, we are mandated to report any abuse to APS in the past. Right now, is there a specific form that we need to sign again, or the old one, or is the old one still works to verify understanding of mandated law? Good question. As a mandated reporter, you're required to sign an acknowledgement that you're aware of the mandated reporting laws, and that you know your duty to report. The law didn't really change who you report to in terms of your previous reporting. Even before AB 40, if the abuse occurred in a facility, you would report to either local law enforcement or the ombudsman program. If the abuse occurred in someone's home, you would report to either the local law enforcement or the Adult Protective Services program. I don't think there's necessarily a need to sign a new form if you've already completed one in the past. That form needs to be updated as well, so there'd be really no purpose in executing a new form right now. We've got a few more minutes, so let's try and take a few more questions. If there is bodily harm, but the perpetrator is caused by a resident with dementia, who do you report to? The 3 entities or only 2? Okay, again, if the resident has a physician's diagnosis of dementia and there's no serious bodily injury, then you would report as immediately or as soon as possible to either the Ombudsman or local law enforcement. You would not have to report that to the licensing agency. Next question. If the victim with dementia is not able to give consent and does not have a legal representative, how can we proceed it? Again, as we discussed earlier, mandated reporters don't need to get consent from residents or legal representatives to report. If a mandated reporter suspects abuse, then the mandated reporter is obligated to report it to either local law enforcement or the Ombudsman or APS, depending on the circumstances that are described on that mandated reporter flow chart. Next question. Instead of mentioning diagnosis of dementia, it is more accurate to mention any disease with symptom of dementia or with moderate to severe cognitive impairment, because Alzheimer's disease, Parkinson's disease could have symptoms of dementia, but diagnosis is not dementia. Good point. Unfortunately, that's not how the law was phrased. So we have to go with what the legislature and the governor have approved and have signed off on. That's not to say that this definition couldn't be changed later to include other types of disabilities and cognitive functioning. But for right now, this is what we're dealing with. Next question, does the participant or his or her authorized representative have the right to know what action or actions are being taken against the suspected abuser? When ombudsmen investigate complaints and we resolve complaints, whether it's an investigation of abuse or another issue, we generally report to the complainant the outcome of our investigation and what has happened. So in this situation, if a complainant asked us what was happening, we would report what was being done. I don't know if I would phrase it as a right to know, but rather, you know, there's an obligation on the part of our program to inform complainants of the outcome of our investigations. We've got about a minute left. Let's see if I can get any more questions in. What are our responsibilities with patient with dementia of the caregiver convince them to take money out of their account and we have no info where the money goes? Okay, that could be considered financial abuse, and so in that situation, if you're suspecting that, the call would either go to local law enforcement or local APS. We'll take one more question, and the rest we'll respond to by email. If it sounds like a patient with dementia caused bodily harm, which has to be reported to local law enforcement might prosecute. In the past, individuals with dementia have been jailed, much to their detriment. Agreed, and that's why we have that provision in AB 40 that if the abuse has been caused by a resident with dementia, it might be better to send that report to the local ombudsman program. Okay, well, I'm glad we had this opportunity to answer some of these questions. As I said, we'll get back to those people who asked follow-up questions or asked additional questions in response to the presentation today. Again, I would encourage you to use the mandated reporter flow chart that's posted on the screen now. Copies are available from your local long-term care ombudsman program. Feel free to reproduce the one that was sent to conference participants yesterday. We suggest that you print these out and actually write on there the phone numbers of the local law enforcement agency that you're reporting to and the fax numbers of local long-term care ombudsman, the law enforcement agency, and your licensing agency, so that mandated reporters have this information in an accessible way. Again, thank you for your time today on this important subject, and if you have any additional questions, please feel free to contact us on our crisis line. That's 1-800-231-4024. Again, 1-800-231-4024. And thank you for your time today.